Hello everyone, my name is Sanmati Israo. I'll be discussing Tata Sons versus Cyrus Mistry case today. So this will be the outline of the case. First, I will be dealing with the background of the company. Then I will be explaining about operation and mismanagement. Then the governing law, timeline of events, legal battle, then the conclusion. Tata Sons is the holding company of the Tata Group, one of the largest and most respected business conglomerates in India. Here's a brief timeline of significant events in the history of Tata Sons. In 1868, Tata Sons was established by Jamshedji Tata, a visionary industrialist, as the holding company of his ventures. In 1932, Tata Steel, one of the significant companies under Tata Sons, was listed on Bombay Stock Exchange, marking a major milestone for the company. In 1938, under Sir Dorabji Tata, Tata Sons expanded its reach into various industries including electricity, textiles, and hospitality. In 1950s and 60s onwards, Dorabji Tata focused on expanding the group's diverse interests, which led to the birth of uh, Tata Air India and TCS was established in 1968. Later on in 1980s and 1990s onwards, the group under the leadership of Ratan Tata began its foray into global market. Tata Group acquired Tetley Tea in 2000 and Jaguar Land Rover in 2008, marking its significant ambitions in the global market. In 2012, after leading the group for 2 decades, Ratan Tata retired as chairman of Tata Sons. His successor, Cyrus Mistry, was appointed as chairman. In 2016, Cyrus Mistry was removed as the chairman of Tata Group. This led to a period of intense legal and corporate battles between Ratan Tata, briefly returning as the interim chairman until N. Chandrasekaran was appointed as the new chairman in 2017. Later on, in 2017 and onwards, under N. Chandrasekaran's leadership, Tata Sons has continued to expand its global presence. Tata Group has strengthened its position in industries like technology, automobiles, and consumer goods. And here, if you see, approximately 66% of equity share capital of Tata Sons is held by philanthropic trusts, which supports education, health, art, culture, etc. The next major of 18% is controlled by Shapoorji Pallonji Group, whose heir apparent is Cyrus Mistry. The word oppression in common parlance refers to a situation or an act or instance of oppression and or subjection to cruel or unjust impositions or restraints. The term mismanagement refers to the process or practice of managing ineptly, incompetently, or dishonestly. However, it is pertinent to be mentioned here that the term oppression and mismanagement has not been defined in the Companies Act 2013, and it's left to the discretion of the court to, and it depends on facts and circumstances of each case. The rule of majority, which was held in Foss versus Harbottle, was applied in the present matter. In Foss versus Harbottle, the principle of majority emerged, which meant that the decisions taken by the majority shareholders were binding on the small shareholders unless and until the action which was taken was illegal or fraudulent, and ultra vires the mandates of AOA and MOA. After in the aftermath of Force's Harbottle, a principle called derivative action emerged, which stated that shareholders could bring an action against the company when majority shareholders are implicated in the wrongdoing, and for cogent evidence have to be submitted for the wrongdoing on part of the majority shareholders. Here, as stated in the slide, once a resolution is passed by the majority, it is binding on all the members, as a result of which the court will not ordinarily intervene to protect the minority interests affected by the resolution. The minority shareholders can nevertheless file a case for oppression and mismanagement. This is the provision under the Companies Act which has been dealt with in the matter, that is section 241. So here if you see, any member of the company, that is the shareholder, can complain regarding the affairs of the company if it is run in a prejudicial manner, to public interest, as well as the interests of the shareholders, as well as to the interest of the company. So timeline of events is as follows. Mr. Cyrus Mistry in 2012 December was appointed as the chairman of Tata Sons. In 2020, 2016 October 24th, Cyrus Mistry was removed from the position of chairmanship. And 2016 October 25th, Tata Sons filed caveats to prevent ex parte orders from being obtained by Cyrus Mistry. In December 2016, Cyrus Mistry filed a case for oppression and mismanagement. How did Mr. Cyrus's ouster happen? In the board meeting of Tata Sons Limited on 24th October 2016, Cyrus Mistry was replaced from the position of executive chairmanship with immediate effect on the ground of trust deficit and repeated dispatches from the culture and ethos of Tata Group, and Mr. Ratan Tata was appointed as the interim chairman of Tata Sons. Later on 25th October 2016, as mentioned in the timeline of events, Tata Sons obtained caveats and stopped Mr. Cyrus Mistry from obtaining ex parte orders. In turn, Cyrus Investments Private Limited and Sterling Investment Corporation Private Limited, belonging to the SP Group, filed a petition before the NCLT under Sections 241 and 242, read with Section 244 of Companies Act, on the grounds of unfair prejudice, oppression, and mismanagement. Legal battle. Tata Sons, during the pendency of the case in the NCLT, called for an EGM, and subject matter was being the removal of Mr. Cyrus Mistry as the chairman of Tata Group and as well as director of Tata Sons. Later on, the two companies, that is Cyrus Investments Private Limited and Sterling Investment Corporation Limited, filed miscellaneous application for waiver of requirement of Section 244, subsection 1, clause A, along with a demand to put a stay on EGM for removal of Cyrus Mistry. On 6th February 2017, shareholders of Tata Sons removed Mr. Cyrus Mistry as director of Tata Sons. Cyrus's allegation for oppression and mismanagement. The AOA per se was oppressive as it ensured that Sir Ratan Tata Trust and Sir Dorabji Tata Trust controlled the affairs of the company. There was huge interference from Mr. Ratan Tata and Mr. N.A. Soonawala in every decisions of the company. And he was also against the continuation of business of nano cars project undertaken by Tata Motors upon insistence of Mr. Ratan Tata, and illegal removal of Mr. Cyrus Mistry as the chairman of the company, which was in violation of law, principles of governance, fairness, transparency, and probity. Acquisition of Chorus at overpayment by Tata Trusts. Mistry argued that acquisition was a misstep for Tata Steel and had led to significant losses. The acquisition had overstretched company's resources and caused long-term financial strain. He also argued that Tata Steel's strategy should be reoriented and it should focus on strengthening its core operations, particularly in India, rather than continuing to invest heavily in underperforming international ventures. So if you see here, there were two divergent perspectives that were operating in the company, and there was no way anything related to operational mismanagement just proved in the case. In the subsequent slides, you will see that the action for operation and mismanagement failed in the matter. Let us see how it failed. So the Mumbai branch of NCLT dismissed the petition under Section 241 to 42 of Companies Act 2013 for no cause of action was established in the allegations stated by the petitioners. They did not even meet the 10% ownership in the company for filing the case for oppression and mismanagement under the Companies Act, and the NCLT did not take the proviso into consideration, which also stated that people who were not a part of minority shareholders could also file a case against the management of the company for operation and mismanagement. In its detailed judgment, NCLT stated that the allegations regarding AirAsia were with impunity, and Mr. Cyrus Mistry had flouted all legal principles. And Nano Project, which was the allegation leveled against it, the NCLT held that the allegations were made without making Tata Motors a party to the matter or the case. The NCLT also rejected allegations of acquisition of Chorus and the transaction made by Shiva and Sterling Group. The bench also stated that it found no merits in the arguments of oppression of minority interests as well as operational management of Tata Sons. Later on, the NCLT rejected the petition and the company appealed to the NCLT. Then decision of the NCLAT. The NCLAT gave its decision in favor of Mr. Mistry and set aside the order of NCLT. NCLAT reinstated Mr. Mistry as the executive chairperson of Tata Sons for his remaining term and declared that the appointment of N. Chandrasekaran as executive chairman of Tata Sons was illegal and suspended its implementation for 4 weeks in order to provide time for Tatas to appeal. NCLAT order had also set aside Tata Sons' decision to convert itself into a private company. NCLAT had concluded that Mr. Mistry's removal from Tata Sons board had no basis and it was a violation of principles, law, as well as fairness, transparency, and property. The abuse of power by the directors nominated by Tata Sons also led to significant losses at Tata Sons Group companies. Grounds to approach the Supreme Court. Restoration of Cyrus Mistry undermined the corporate democracy and he was replaced after majority shareholders held that he has to be replaced in the board meeting. As stated earlier, in the case of Foss versus Harbottle, it was held that the majority shareholders' decision taken by the board will be upheld over minority shareholders and their opinion or anything that they tell the board meeting will be taken into consideration nevertheless, but the majority shareholders will be taken into consideration over minority shareholders. Then Mr. Mistry never sought for reinstatement after his tenure had ended, and NCLAT's conclusions are based on the error that Tata Sons continues to be a private company. Then NCLAT imposed an unsolicited consultative process by asking the Tatas to consult minority shareholders Shapurji Palansi Group before appointing the executive chairman. On March 26, 2021, the Supreme Court reversed the NCLAT order and ruled in favor of Tata Sons, citing that the removal from the post of directorship cannot be called an act oppressive to the minority shareholders. The court held that valid and justifiable reasons and could not be termed as oppressive or prejudicial in the eyes of law. In its judgment, the Apex Court noted that the provisions contained in the 2013 Companies Act only protected the rights of small shareholders of listed companies by asking such companies to have on their board at least one director elected by such small shareholders. Grounds for rejecting NCLAT order. As stated earlier, I will be reiterating again that there were valid and just reasons because of which Mr. Cyrus Mistry was replaced from the position of chairman as well as director of Tata Sons, and it was nowhere operative or prejudicial to the interests of the company or prejudicial in the eyes of law. And Mr. Cyrus Mistry had also leaked the mail dated October 25, 2016 to the media and sent replies to tax authorities even while continuing as a director. Mr. Mistry's family did not have any representation on the board as they were minority shareholders. Conclusion: the AOA could have contained provisions related to the powers of Internal Complaints Committee to investigate the matter related to oppression and mismanagement. The entire crux of the matter could have been investigated by the Internal Complaints Committee, and then when the settling terms were not formed or formulated, the matter could have been elevated to the level of NCLT, and the Supreme Court could have given a wider interpretation of the term minority shareholders and mismanagement and oppression. As you can see that Mr. Cyrus Mistry had opined and argued that rather than investing in underperforming international ventures, the Tata Steel should have focused on strengthening its core operations, particularly in India. The Supreme Court got confused with corporate hegemony and corporate democracy. Democracy is a situation where when an outsider could question the decisions taken by the majority shareholders, not just the minority shareholders. So, I would like to conclude by stating that these are the recommendations and suggestions that I'll be giving upon the matter that was discussed today. And I think so. Mr. Cyrus Mistry should have been given more than 10% as he had been working for Tata Group since time immemorial. Thank you.